Well, I've seen some videos in my day describing the Kyle Rittenhouse saga, but this one takes the cake. This is a lawyer by the name of Mirriam Seddiq, and she has a channel called Trials and Errors, and she's now going to tell us all about Kyle Rittenhouse and what took place, and she's going to analyze this thing with keen legal insight. The title, Kyle Rittenhouse shooting, was it self-defense? No way. Let's see about that. Hello out there. I am trying to get through.
With his powerful brainwaves cradled in the warmth of reasoning, it's time for Johnny Walker Dredd to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnny Walker Dredd Show.
And away we go.
Hi, welcome to Trials and Errors. I'm Mirriam. Today we're going to talk about Kyle Rittenhouse. He's the 17-year-old from suburban Chicago who one night decided to go to Kenosha, Wisconsin, where there were protests that turned violent in the evenings, to protect the community.
They had volunteered to go and protect the car lot, which is located pretty far from any of the violence and protesting that was going on that night. We have video coverage of that. He and a couple others hanging out at the car lot, having a good time, and you can see in the far distance all the mayhem going on. They're perfectly tent, which is staying there.
And at some point he comes across a gentleman who had apparently just been released from a psychiatric facility that day, and he killed him.
Okay, psychiatric facility is a really nice way of describing a mental health care clinic where he was undergoing treatment because he's a nut. He has bipolar disease. He's also a meth and heroin addict. Furthermore, she completely glosses over this to make it look like he was just somewhat of a man who had maybe some mental troubles. No, he has a violent past. He had raped 4 boys, ages 9 to 11, served 10 years in jail, so he's a felon. Furthermore, he beat the living crap out of his wife. That's why he was in the mental health clinic in the first place. He's a domestic abuser. And you also notice she always prefaces the word claims whenever she wants to downplay something, where they claimed they were protecting property. No, they were protecting property. We have them on video doing it. They have their rifles, they're standing, and they are telling people, hey, just move on down the street. We don't want any trouble here. Move on down the street. We're just here protecting the property to try to keep people from burning it. So, but she's going to say, oh, well, they were just claiming to. So this is how one way to bias your narrative, and that is by putting the claim in front of all of these. However, whenever she wants to bite into Kyle, she won't use that terminology. She will move away from it, and it'll be like a certainty in the way she describes it.
That was Loco, but not in an entertaining way.
Needless to say, shooting an unarmed man, it attracted some attention.
He was grabbing hold of Kyle's rifle. He's not unarmed. Once you get a hold of somebody's rifle, you're basically taking the rifle from them and arming yourself. Furthermore, the other thing she doesn't mention, as a convicted felon, he can't possess a rifle. So she makes a big deal out of the fact that Kyle's walking around with a rifle. He's underage. He's trying to take a rifle from a kid, and he is not allowed to have a rifle. He is actually committing a felony by possessing that rifle. He's trying. Kyle prevents him from doing so. She's not going to mention that part, though.
When we're not busy talking about people who show up with AR-15s at night during protests and riots looking for trouble. Kyle was...
Okay, so here's the issue, and a lot of people have missed this. She probably comes from a city. I don't know much about her background, but I would bet she probably lives in New York City or Washington, D.C. or something like a major metropolitan area. And they just don't understand what it's like to have people walking around with rifles. But if you were there in Kenosha that night, you will see almost everybody is armed. There are tons of AR-15s being carried around. However, she doesn't understand that kind of climate. And so when she hears the story about young Kyle walking around with an AR-15, by the way, you know she has to mention AR-15 over and over and over again. Well, to them, that's that spooky gun that has all that mystique behind it. But it's a rifle. It's like a rifle as far as Wisconsin state laws are concerned. They make no distinction between an AR-15 and any other long rifle. So here she is. She hears about this kid walking around with a rifle, and in her mind, in an imagery, she sees peaceful protesters chanting BLM, BLM, like they're legally allowed to. And here goes Kyle walking around with his AR-15, scaring the bejesus out of everybody. Didn't happen. We went through this. This is one of the videos I presented, and I showed the reaction of the crowd to Kyle and his rifle. There was no reaction.
I mean, there was a kind of a mob that surrounded him at that point, and he may very well have felt threatened. He was down on the ground, and there's a video of all of this. I mean, of course, these days everybody just pulls out their phone and watches it all take place and then uploads it onto the internet. And Kyle says he felt threatened. One of the people had a gun, and so of course he did the only reasonable thing, which is shoot 2 more people. One of those people ended up dead. The other one was seriously injured. It turns out that nobody actually had a gun.
Hi, I'm the most local person in here.
Okay, and I think most of you out there, I think even the anti-Kyles, those who are convinced that Kyle must go to jail, went, oh no. How could she blow this? I mean, I can't imagine how she could not know that Gage Grosskreutz, who is the person she's talking about, actually had a gun that night. He pointed it at Kyle. It's on video. We have still frame photos of him, and it's a gun. And he admitted it after the event was over. He even went on interviews to explain that he was illegally allowed to carry that gun. Here she is. This is in February 2021, and she still thinks that Gage was unarmed. Incredible. She has not paid attention to anything associated with this story.
One of the young men had a skateboard. I think if you review the video, when you see him shoot these 2 people when he's on the ground, you could believe that. You could believe, yes, this is a legitimate self-defense claim. And
yeah, why? Because he's on the ground. He is on the ground and they're attacking him. Oh, by the way, I should mention that skateboard she's talking about earlier. Guess what? Skateboard is a lethal weapon if you hit somebody in the head with it. How do we know that? Well, we have a Eureka man that was killed by one. He was struck in the abdomen and he died from internal injuries. Any hard object that is aimed at the head is a deadly weapon. Can a skateboard cause death or serious bodily injury? It doesn't have to kill somebody, but it has to be capable of inflicting serious bodily injury. Can a skateboard do that? Oh, hell yeah. Hell yeah. These things, they're not the little cute ones that we used to ride around on when we were a kid. These are pretty good size objects. You swing that at somebody's head, you can knock them cold, and you can give them a concussion, and you can kill them. Gage was armed with a pistol. He was armed with a skateboard.
Self-defense in most states is an affirmative defense. And what that means is that the state puts on its case and it says this particular thing was a murder. It lays out the elements of murder during the course of the trial. It will introduce witnesses potentially who say they saw you do it, you admitted to doing it. There may be physical evidence, DNA, fingerprints, videotapes, what have you.
Okay, that was weird.
She doesn't know what affirmative defense is. That's not affirmative defense, what she's describing. Affirmative defense is a defense that you take when you commit a crime, or at least you commit acts that fit the definition of a crime. You agree to have committed those acts because you're going to claim that other extenuating circumstances release you from responsibility for taking action. For example, the most common, self-defense. So there is a law against attacking somebody, especially with a firearm. There's in the law, I can show you the statute. And by reading that, you think, well, Kyle is guilty. He did these things. And Kyle will go on and say, yes, I did those things that this law says is against the law, is a crime. However, with affirmative defense, he's saying, but I was acting in self-defense. So an affirmative defense is one where you admit to committing the elements of a crime, but then you turn around and you claim that in so doing, you are not guilty because of other extenuating circumstances. And I can't imagine how she blew this. The one example is one that I disclosed yesterday in the case of Marissa Alexander. She goes over to her estranged husband's house and takes a shot at him. doesn't hit him. It looks like she tried to, and she missed. And by the way, she had a restraining order against her, okay? And when the police arrived, she didn't say, yeah, I tried to shoot him because he was attacking me. She said she fired a warning shot. So she's not taking an affirmative defense there at all. She's not admitting to the elements of the crime of attempted murder. Well, that was a problem. Because if she had hired a lawyer, the lawyer could have told her that taking a warning shot is illegal in Florida. It was at the time. They've changed the law since then because of this case. However, at that time, she could not claim that she only fired a warning shot because doing so would have been a crime. So here, the case that she didn't take an affirmative defense landed her in a lot of trouble. She ended up doing 3 years of jail or prison time. She was facing 60 years for that. Why? There were 20 years maximum sentences, but there were 3 people in the room that she shot at, 3 counts, consecutive 60 years. Luckily, she plea bargained out and she served 3 years, which I think is much more amenable or much more reasonable considering that she actually didn't end up shooting somebody. The fact that she missed has to be taken into account. My gosh, I mean, she might as well have murdered all 3 of them if she's going to get 60 years. So that's an example where you have to take an affirmative defense to be able to put up a defense.
Say it's self-defense, you have the burden of proving it. What?
She's also dead wrong about proving self-defense. You don't have to prove self-defense. All you have to do is provide the court some evidence that self-defense was in action here, and the prosecution has to prove that it was not. Okay, so let's take a look here. This is the Wisconsin jury instruction for criminal cases here, volume 1, and let's go on down here. And down here, guess what it says here? State and burden proof. The state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant did not act lawfully in self-defense. These are the jury instructions. Read them. It's clear.
And that evidence has to meet the threshold of beyond a reasonable doubt. So what do you have to prove if you're someone who says, plead self-defense? This was a self-defense case. Well, you have to show that you were not the initial aggressor, meaning you didn't do an act.
That's false. This is another misconception a lot of people have who are not familiar with Wisconsin state laws. In Wisconsin, you can even provoke the violence, but if you attempt to flee and you make it known to the other person that you are breaking off the contact, then you reassert your self-defense rights. I went through this in a video. It's in the Wisconsin statutes, and there's a whole ton of lawyers out there who have web pages where they devote space on this, and they all say the same thing. By the way, these lawyers are from where? Wisconsin. You have to know your state laws. She's dead wrong on this. I really doubt that she's correct even in her own state.
Now, the whole reasonable person standard is really interesting, considering I believe that the reasonable person was always meant to be a white man in society.
You are so loco, man!
So white men had a reasonable belief to be afraid when they were amongst a group of...
Well, she feels on safe ground here. She's obviously a social justice warrior, and she likes to talk in these type of terms, and so she's going to pound this racial thing going forward. But let me explain the reasonableness to you. And the question is that if a person uses self-defense or is claiming self-defense, the question is that did they have a reasonable belief that they faced death or serious bodily injury if they did not take action? She got that part right. Here's the other part that she missed out on, and that is, what is reasonable belief? The jurors will be instructed to consider what would a reasonable person of moderate or normal intelligence and behavior do in this circumstance. Now, you may think, well, that's pretty obvious. There's no difference there between what I would normally think that the defendant would believe. But here is the issue. Suppose that you're a juror and you're a Navy SEAL or you're a martial arts expert. You might think to yourself, if I was in that situation, I wouldn't have shot him. I would have taken his gun from him. Or another scenario, suppose that you're a real scaredy cat In other words, you have a terrible fear of being attacked, and you would have panicked. You know you would have panicked, and you would have opened fire. Neither one of those jurors are examining this the way they should. What they should examine it is, what would a person of normal intelligence and behaviors and beliefs do? And that's the person you have to put into the place of the defendant. Now, Kyle Rittenhouse is a 17-year-old kid and seems to be pretty normal in just every respect. If he had a reason to believe he was in fear, there's probably a good chance that you would have too.
Black men, for example, or in a predominantly minority neighborhood. So those were things that somebody could look at and say, well, it would be reasonable to be afraid if you were this kind of person in that kind of place. And I'm not sure if Wisconsin has a stand your ground law. In many states, you do have a duty to retreat if you can.
Kyle was not standing his ground.
Loco! Huh?
At what point in the video is he standing his ground? He's running from Rosenbaum. He's running from the mob. He's trying to get away from him. He's not standing his ground. A stand your ground law is irrelevant in this case.
And safely, unless you're in your home, in which case you have something that's called the castle doctrine, because you know, your home is your castle. So Kyle Rittenhouse's case brings up a couple of interesting points. The first is, if you shoot someone, but it's not the person that then comes and attacks you, are you the initial aggressor? I say yes, because you should not be able to, I don't know, walk into a Target, shoot a person, have a bunch of people come at you to either prevent you from shooting it or, I don't know, just being really angry that you just shot a person and killed him in cold blood, and then have you continue to shoot them.
This is emotional argument. She's not basing it on any statutes. She's basing her argument on what she thinks it should be. And so she's going to create this scenario that says, well, I think the law should be this because what if you were in Target and what if you're doing that? However, I have a different approach. I read the law. What does the law say about these incidences? I went through it. A 1-hour video I have on my channel where I walk through the Wisconsin self-defense laws one item after another. There's even a section on offenses to third parties that may have gotten in the way while you're defending yourself. And by the way, that favors Kyle as well. So she's not presenting a legal argument here. It's just, well, what do I think? We don't care what you think. What matters is, what does Wisconsin law say?
I don't really know all of the facts of this case, and I don't practice
You don't know any of the facts of the case.
In Wisconsin, so I can't say what would happen in Wisconsin in particular, but...
Well, why not go and read the Wisconsin statutes? I did. Now, for the record, I'm not a lawyer. However, I know self-defense laws. Been at this for a long time. And when I read Wisconsin statutes, I read them line by line. I read case law on it. I even made a video. I made a bunch of videos on it. One of my videos is an hour long. It walks through line by line all of the self-defense statutes in Wisconsin. Guess what? Kyle's getting off. You got not a prayer of convicting that boy. And the reason why is the law agrees with him, not you. So why not take some time out of your day, read the Wisconsin statutes? I mean, I understand that your background in this is based on sort of what you have grown up with, maybe in your own home state, but Wisconsin has very permissive self-defense laws. It has very permissive gun ownership laws.
From what we know so far of this case, young Mr. Rittenhouse was in the wrong from start to finish.
It's like watching the British version of The Office. Like, it's funny, but awkward and sad at the same time.
Yes.
When he was asked by the Washington Post, he actually gave them an interview, and they asked him, why did you bring this gun? He said, well, I brought it because I thought I would be killed. But we know that that's absolutely not true. He brought the gun because he could. That's really it.
Cite your evidence. Cite your evidence. You say that Kyle was wrong, that he did not bring that gun for self-protection. And then you say, and we now know, really? Okay, show me the evidence that he brought that gun to commit any kind of crimes or cause any harm at all. Show me the evidence, because we have hours of footage of Kyle. I have gone through the footage. I have videos on it. We walk through all of his actions that night that's available, and it's lengthy. And guess what? There isn't a shred, not a shred of evidence that he was out there to provoke anything.
There's no other reason for him to go. And not only that, but he was not legally allowed as a 17-year-old to carry that gun.
I'm crazy. I'm the loco one.
Okay, so let's see here. We have a number of cases, and I brought this up. This is a dumb argument. Well, she's made a lot of dumb arguments, but this is one of those dumb arguments I focused on in one of my past videos. And that is, well, if you're carrying your gun illegally, you can't claim self-defense when using it. Oh, yes, you can. You absolutely can. The law does not say that you cannot use a gun that you have illegally to protect yourself. And I brought up a number of cases on this. One case out of Oklahoma, 11-year-old girl. She's in her house. Somebody breaks in. Dude has a knife, by the way. She pulls out a gun, a shotgun, in fact, and shoots him. And he runs off. I don't think he died. Afterwards, they had an interview with her, and like all good Oklahoma girls, she's like, yeah, well, he walked in and I shot him. Oh, it's sweet. I really love her. This was probably about 5 or 6 years ago. At any rate, according to her argument, though, she can't claim self-defense. She can't possess a shotgun. It doesn't matter if she's in her own home. She can't possess a shotgun. That's what the law says. Her mother wasn't home, so she was unsupervised. So according to the argument, she couldn't do that. We had another case near Tulsa where a young kid, I think it was 14, had people invading his home, and he opened fire with an AR-15, killed 3 of them. He cannot legally possess that rifle. In Oklahoma, you have to be 18, unsupervised. And yet, no charges. I understand that when you look at a particular event, it's easy to formulate in your mind what you think the law should be based on the outcome of that event. But as a lawyer, she should know that you have to broaden that, and you have to understand that the law is going to be more generally applicable than on these certain special events alone. And so no state has a law that says that you cannot defend yourself with a gun that you are not legally allowed to possess. And of course, another thing is, Joseph Rosenbaum, he tried to grab Kyle's rifle. He's trying to arm himself with Kyle's rifle. He's a felon, cannot possess a rifle. But nobody ever uses that argument. Nobody ever focuses on that. So here's the deal. If you want to talk about Wisconsin self-defense laws, you got to know what you're talking about. And if you think that Kyle Rittenhouse is going to be convicted because he could not legally possess that rifle, you are in for a major disappointment. You saw the judge, he ain't going to go for this. All this emotional social justice, BLM, people of color talk isn't going to go very far there. He is totally impervious to this emotional crap. He's going to look at the law. The law is on Kyle's side.
With this bandana, I welcome you to the game.